The Supreme Court has already reshaped the Second Amendment landscape in profound ways over the past 2 decades. In 2008, in District of Columbia versus Heller, the justices declared for the first time that the amendment protects an individual right to keep and bear arms for self-defense, striking down a District of Columbia law that effectively banned handgun possession in the home. Yet even there, the court was careful to note that this right is not unlimited. It does not protect all weapons, and it has long coexisted with regulations on certain arms that were considered dangerous and unusual. Fast forward to today. Millions of Americans own semi-automatic rifles like the AR-15 platform, often described as the most popular rifle in the country. Several states and localities maintain bans on what lawmakers call assault weapons, firearms featuring certain military-style features such as pistol grips, folding stocks, or the ability to accept detachable magazines. Lower federal courts have largely upheld these restrictions even after the Supreme Court's 2022 decision in New York State Rifle and Pistol Association versus Bruen, which required courts to evaluate gun laws against the nation's historical tradition of firearm regulation rather than through modern interest balancing tests. As of early 2026, the Supreme Court has not yet granted review in any case directly deciding whether these bans violate the Second Amendment. Petitions challenging laws in Maryland, Connecticut, Cook County, Illinois, and elsewhere have been denied or remain pending, with some justices signaling that the issue may be ripe soon. Justice Brett Kavanaugh, for instance, has written that the court should and presumably will address the AR-15 question in the near term, while noting doubts about certain lower court reasoning. Here's the thought-provoking question for you. If semi-automatic rifles like the AR-15 are among the most commonly owned firearms in America today and are used by law-abiding citizens primarily for self-defense, sport shooting, and hunting, does the Constitution allow states to ban them outright? Drop your answer in the comments below. I read them, and this is exactly the kind of conversation that makes these videos worthwhile. This is an abstract constitutional theory. Imagine you live in a suburban neighborhood where crime rates have risen, and you've chosen a semi-automatic rifle for home defense because of its reliability, accuracy, and the fact that it's lightweight and easy to handle for many people, including smaller-statured individuals or those with limited strength. In states with assault weapon bans, that choice could now be illegal, forcing you to rely on other options or risk criminal penalties. On the other side, families who have lost loved ones in mass shootings argue that these firearms' rapid-fire capability and high-capacity magazines amplify tragedy in ways that demand legislative response. Both perspectives reflect deeply held views about safety, liberty, and the role of government. This video is for educational purposes only. It is not legal advice. If you have a specific situation involving firearms ownership or regulations, please consult a qualified attorney licensed in your jurisdiction who can provide guidance based on current law and your individual circumstances. To understand where we are now, we need to go back to the text of the Second Amendment itself, a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. For much of the 20th century, courts interpreted this primarily through the lens of the militia clause, treating it as a collective right tied to military service. That view shifted dramatically with Heller. Justice Antonin Scalia's majority opinion emphasized that the amendment codifies a pre-existing individual right to possess arms for lawful purposes, especially self-defense in the home. The court invalidated D.C.'s handgun ban but stressed that the right does not extend to dangerous and unusual weapons or arms not in common use for lawful purposes. 2 years later, in McDonald v. City of Chicago, the court made clear that this individual right applies to state and local governments through the 14th Amendment's Due Process Clause. These decisions marked a turning point, but they left many questions open, including exactly which modern firearms fall inside or outside constitutional protection. Enter Bruen in 2022. The case involved New York's proper cause requirement for public carry permits, which the court struck down as inconsistent with historical tradition. The key holding: when the plain text of the Second Amendment covers an individual's conduct, the government must demonstrate that its regulation is consistent with the nation's historical tradition of firearm regulation. No longer could courts simply apply intermediate scrutiny. balancing the law's public safety benefits against the burden on the right. Instead, history and tradition became the guide. In Bruen, the court also reaffirmed Heller's common use principle. Arms in common use today for lawful purposes enjoy strong protection. The decision has led to thousands of challenges to gun laws nationwide, with mixed results. Most restrictions, including many on sensitive places or certain persons, have survived when courts found relevant historical analogs, such as founding-era laws disarming those who posed credible threats or restricting carry in specific locations. United States versus Rahimi in 2024 provided important clarification. The court upheld a federal law prohibiting firearm possession by individuals subject to certain domestic violence restraining orders. Chief Justice John Roberts wrote for an 8-1 majority that the law fits within a historical tradition of disarming those who threaten physical harm to others. The decision emphasized that analogs need not be identical twins, but must be relevantly similar in how and why they burden the right. Justice Clarence Thomas dissented, arguing for a stricter application of Bruen. Many legal observers saw Rahimi as a refinement rather than a retreat from the history and tradition test. Now apply this framework to assault weapon bans. These laws typically define assault weapons by features like a pistol grip that allows shouldering while firing from the hip, a folding or telescoping stock, a threaded barrel for attachments, or the ability to accept a detachable magazine, often combined with a semi-automatic action. They do not ban all semi-automatic rifles, just those with the specified characteristics. Supporters argue these features make the firearms more suitable for rapid, sustained fire in combat-like scenarios, increasing risks in mass shootings or criminal use. Opponents counter that the same features enhance ergonomics and usability for lawful self-defense, competition shooting, and hunting, and that the banned guns are functionally similar to many unprotected semi-automatics. A common misconception is that assault weapon is a technical military term. In reality, it is a legislative label that varies by jurisdiction. Another myth is that these bans target fully automatic machine guns. They do not. Fully automatic firearms have been heavily restricted under federal law since the National Firearms Act of 1934, with civilian ownership of new ones effectively prohibited since 1986. Semi-automatic rifles fire only one round per trigger pull, just like many handguns and traditional hunting rifles. Post-Bruen, federal appellate courts have, so far, uniformly upheld state and local assault weapon bans when directly challenged. The Fourth Circuit, sitting in bank, reaffirmed Maryland's ban, concluding that the firearms at issue are military-style weapons ill-suited for self-defense, and that history supports regulating exceptionally dangerous arms. The Seventh Circuit in cases involving Illinois and Cook County has similarly upheld restrictions, often emphasizing that the Second Amendment protects weapons in common use for self-defense, but allows regulation of those more akin to military arms. The Second, First, and Ninth Circuits have reached comparable conclusions on related challenges. No circuit has struck down an assault weapon ban outright since Bruen, though some district courts have issued narrow or preliminary rulings that were stayed or reversed on appeal. Critics of these rulings argue that they misapply Heller and Bruen by focusing too heavily on the military character of the firearms rather than their widespread civilian ownership and lawful use. They point out that millions of AR-15 style rifles are in circulation, owned legally in 41 or more states, and used primarily by law-abiding citizens. In their view, labeling them dangerous and unusual ignores the common use test. Defenders of the bans respond that commonality alone does not insulate a weapon if it shares characteristics with arms historically subject to regulation, such as those capable of inflicting mass casualties quickly. They also cite 19th century laws restricting Bowie knives or other dangerous, bladed weapons carried in certain ways, arguing these reflect a broader principle of limiting unusually lethal implements. In my analysis, the tension comes down to how courts characterize the how and why of the regulation under Bruen and Rahimi. If a ban targets weapons because they enable rapid fire in ways disproportionate to typical self-defense needs, supporters see a relevant historical parallel in traditions of disarming threats to public safety. Challengers see a categorical prohibition on arms that ordinary people actually choose for lawful purposes, with no clear founding era or Reconstruction-era analog for banning entire categories of bearable arms in common use. What does a ban actually do, and what does it not do? These laws generally prohibit manufacture, sale, transfer, and possession of covered firearms within the jurisdiction, often with grandfather clauses for previously owned guns, though some require registration or other restrictions. They do not disarm law-abiding citizens entirely. Other firearms remain available. They also do not affect federal background checks, age restrictions, or prohibitions on felons and certain other disqualified persons. In practice, enforcement varies, and many owners in banned jurisdictions retain pre-banned firearms under grandfathering provisions. For ordinary Americans, the practical impact can be significant. A hunter or sports shooter in a banning state might need to switch to compliant configurations or travel out of state. A homeowner concerned about self-defense might face limited options or added legal complexity. On the other side, communities that have experienced gun violence see these laws as one tool among many to reduce the firepower available in potential attacks. Neither side's position eliminates all risk. Firearms remain widely available in most of the country, and crime statistics involve complex social factors beyond any single regulation. Another connected landmark case is worth noting briefly: Catano versus Massachusetts in 2016, where the Supreme Court unanimously held that stun guns are protected arms because they are in common use for lawful purposes, rejecting the idea that only weapons in existence at the founding qualify. This reinforced that the Second Amendment adapts to modern technology while remaining rooted in history. As litigation continues in circuits like the Third, Seventh, and others, with cases such as challenges to New Jersey, Illinois, and Connecticut laws working their way forward, the Supreme Court faces mounting pressure to provide clearer guidance. Some justices have expressed frustration with lower courts' handling of common use questions, while others emphasize the need for sufficient percolation among the circuits before stepping in. Petitions like Viramontes versus Cook County and National Association for Gun Rights versus Lamont highlight the ongoing debate. What do you think? Has the evolution of Second Amendment law after Bruen changed how you view everyday firearms ownership or public safety measures in your own community? Feel free to share your experiences thoughtfully in the comments. Here are the 3 most important takeaways. First, the Supreme Court has not yet ruled directly on whether state assault weapon bans violate the Second Amendment, but the issue is percolating through the lower courts with petitions pending that could reach the justices soon. Second, under current doctrine from Heller, McDonald, Bruen, and Rahimi, the analysis turns on whether the firearms are in common use for lawful purposes and whether the bans align with historical traditions of firearm regulation, questions on which reasonable minds and courts currently differ. Third, these laws affect real people's choices about self-defense and recreation, but they operate alongside long-standing federal restrictions and do not represent a total disarmament. Understanding this area of law matters because the Constitution's protections and their limits shape the balance between individual liberty and collective safety in a country where firearms are deeply embedded in culture and history. Clarity from the Supreme Court could bring uniformity or further refine the boundaries. In the meantime, stay informed, respect the rule of law, and remember that constitutional questions like these are ultimately about how we govern ourselves as a free people. This has been a detailed look at a complex and evolving legal frontier. If you found it helpful, consider liking and subscribing for more straightforward legal analysis. Thanks for watching, and I'll see you in the next one.